You're probably looking at your debts and thinking, I'm out of options. You've spent nights Googling bankruptcy, talked to a couple of lawyers, maybe even read about offshore trust, yet still feeling like you don't actually know what is safe or even legal in California. And if you guess wrong, you could lose everything, your home, your retirement, even assets you thought were actually protected. I'm Talai, an asset protection attorney here in California, and I help people in exactly this situation. This video walks you through your two last resort options, bankruptcy versus asset protection trust, so you can make a real decision with full clarity on what is at stake. Let's start with bankruptcy because for a lot of people, that is the first word that comes to mind when things get tough. Bankruptcy is a legal process you can go through in court when you cannot pay your debts, but it doesn't fix everything, and it's not a magic get-out-of-debt-free card. In California, the two main types of bankruptcies for individuals are Chapter 7 and Chapter 13. Chapter 7 is liquidation. It means a court trustee may sell off some of your things to pay your creditors. Thank God California does allow you to keep certain essentials like tools you need for your work, a modest car, and a part of your home equity, the home that you personally reside in. Chapter 13 is more like a payment plan. You keep your property, but you stick to a strict court-approved budget for 3 to 5 years, sending most of your extra income to creditors to pay down the debt. But here's what most people don't realize. Bankruptcy does not wipe out every type of debt. Things like student loans, most taxes, child support, court fines, they stick around. You also can file for bankruptcy and just hide your assets. California courts take that very seriously. If you try to transfer your stuff to your family or friends right before filing, that is called a fraudulent transfer, and it's a fast way to lose everything and possibly face criminal charges. Who should actually consider bankruptcy as a last resort in California? Let's take a look at two examples. First example is Sarah, who is a small business owner in Los Angeles. COVID wiped out her revenue, and she's got about $200,000 in credit card bills and business loans. Her home's fair market value has dropped now, and she has about $340,000 in home equity in her personal residence. With creditors closing in, bankruptcy could let her wipe the slate clean, keep her car and her home under the California's now somewhat generous exemptions, and rebuild. The second example is Mike, and he is a Bay Area tech consultant, let's say. He's facing a lawsuit over a car accident with damages over his insurance limit. The plaintiff hasn't won yet, but Mike is terrified. For him, bankruptcy might not help at all. If the judgment says he was reckless, some of that debt may not go away, especially if it's for injuries caused by DUI or intentional acts. Let's be honest here, bankruptcy is not gentle. Here's what you need to know about the risks. First, it destroys your credit for years, making it tough to buy a home, get a decent loan, or sometimes even hard to land a job, especially in financial industries. Second, your bankruptcy case becomes public record. That means if you're a business owner, your reputation can take a hit. Third, California's means test, is strict. If you make too much money, you may be forced into Chapter 13 and pay a bigger chunk of your debt back anyway. And finally, you will have to list everything, every checking account, every safe deposit box, every bit of property you own. If you try to hide something, and unfortunately I talk to people and they come up with these ideas that they're going to transfer property and not disclose things, that is a bad idea because the court usually will find out, and that could mean that you would lose the property anyway and also face criminal charges for perjury. Now, let's talk about asset protection trust. This is the path for people who want to take action before things get out of control. And that's truly when you want to do some planning. An asset protection trust is a special kind of legal structure where you move certain assets out of your personal name and into the trust managed by someone you trust, often in a different state or even overseas, depending on your situation. It is one of the most powerful ways to create legal distance between you and your assets, but it only works if it's done the right way and done early. While California doesn't have its own self-settled asset protection trust statute, a California resident can still legally create an irrevocable trust that provides a very strong asset protection as long as it is structured properly. And that means that you're going to follow either the California's non-self-settled trust rules or use the laws of a favorable jurisdiction such as Nevada, Delaware, Alaska, or South Dakota. All right, so the important part here of creating an irrevocable trust in California and how we could get asset protection is that you cannot create a trust for your own benefit and expect creditor protection. California does not allow self-settled trust, meaning if you fund the trust, you cannot also be named as the beneficiary of the trust. But that doesn't mean you lose all flexibility. Even if you're not named as a beneficiary, the trust can be drafted to give you specific powers that keep you indirectly involved without crossing the legal line. And here's how. You can hold a power of appointment, a lifetime power of appointment, or testamentary power of appointment, or both, letting you decide who ultimately receives the trust assets. You can have the power to remove or replace the trustee, and that will allow you some control, some indirect control over the administration of the trust. You can retain the power to borrow from the trust or swap assets you own for assets of equal value from the trust. You can even have the power to veto certain trustee actions, maintaining oversight without being a trustee. And in more advanced setups, a trust protector and neutral third party can even have the authority to add you back in to the trust as a discretionary beneficiary at some point down the road. Now, a caution, if that ever happens, if you're added back as a beneficiary to an irrevocable trust based on California laws and almost 30 other states, the trust might lose its asset protection because you have regained what courts call beneficial enjoyment. So yes, flexibility is possible, but it must be carefully balanced against the protection you're trying to preserve. Technically, you can name yourself as the trustee of this asset protection trust if you're not the beneficiary of the trust, which again, under California law, but I'm really not certain if that would be the best idea. If you do serve as the trustee or even name a close relative to act as a trustee, a creditor could argue there's implied agreement giving you ongoing control, and that would be the way that they could try to get into the trust. Best practice, appoint an independent institutional or professional trustee. These trustees follow formal fiduciary procedures, maintain professional records, and project the independence that courts respect. If you insist on serving as trustee, your discretion must be limited to an ascertainable standard, typically health, education, maintenance, or support. That is legally acceptable, but not as protective as having an independent trustee using a purely discretionary standard. I'll give you another real-world example, keeping control without losing protection. Take David, a California entrepreneur. He built a successful construction business and set up an asset protection trust 5 years before selling one of his companies. David isn't a beneficiary, but his trust gives him smart flexibility. He can swap assets, remove his trustee if needed, appoint a new trustee, and even direct who will inherit through the lifetime and testamentary power of appointment that he has. When a major lawsuit hits later on from, let's say, an old business contract, the assets in the trust stay completely off the table. He didn't lose control. He just gave up the kind that could be used against him. So, remember, asset protection trusts don't mean giving up control forever. They mean trading direct control for strategic control. You still hold the levers that matters the most, you just hold them at a safer distance, and that is what makes this such a powerful planning tool, especially when designed early and designed the right way. Almost every week, people ask me, can I just move my money to a friend's bank account or a family bank account? What if I put my house in my child's name? I'll transfer it, quick claim it out of my name to their name. That is called a sham transfer in California. If a judge finds out you transfer property to dodge a creditor or a lawsuit, they can use the Uniform Voidable Transaction Act to claw it right back. If it is especially obvious, you could even end up facing extra penalties. If a lawsuit is already filed or debt collectors are knocking, your best move is to get real legal advice quickly. Sometimes bankruptcy is the only reasonable option, especially if you're drowning in debt you cannot pay. Other times, it is smarter to negotiate settlements, to use California's exemption rules to keep your essentials. But if you still have time and your risks are in the future, maybe you're a professional, a business owner, or a real estate investor, an asset protection trust set up before trouble starts could save you from ever having to file for bankruptcy. So here's what you need to remember. If you are already deep in debt and lawsuits, bankruptcy in California can give you a fresh start, but it does come with real long-lasting pain. If you're looking to protect your saving account, checking accounts, your property before anything goes wrong, a properly structured asset protection trust is a better shield. But it's not something, in most cases, you can set up at the last minute. And none of these is a do-it-yourself project. The laws are changing all the time, and the stakes are too high to risk a mistake. If you learned something today, and I hope you did, and you want to know exactly what happens step by step in a California lawsuit and how real asset protection tools can help you sleep better at night, don't miss my next video, the lawsuit process in California explained and how asset protection shields you. This one is a must-watch if you want to protect your rights and keep your family's future safe. See you over there.